We'll hear argument next in Case 18-1109, McKinney versus Arizona. Mr. Katyal.
Thank you, Mr. Chief Justice, and may it please the Court. The State seeks to put James McKinney to death, even though he's never once had a sentencing proceeding that complies with current law. There are two separate paths for McKinney to win. The path in Question 1 argues that the Arizona Supreme Court reopened McKinney's sentencing proceeding. The Ninth Circuit had earlier granted a conditional writ of habeas corpus and gave the State the option of either imposing a life sentence or seeking the death penalty again. The State chose the latter, which required brand-new State action in the form of new sentencing. The Arizona Supreme Court then did everything itself, just as it had in 1996. That was wrong. This Court's decisions in Ring and Hurst required a jury sentencing. If McKinney were sentenced today, no one doubts he'd be entitled to a jury trial. The State claims this would open the floodgates, but McKinney is not seeking to use Ring retroactively as a sword to challenge his earlier proceedings. Rather, he's saying that when the State conducts a new proceeding, that sentencing must comply with current law. Otherwise, the implications would be frightening. For example, a State could run a resentencing today in 2019 with a pre-Batson jury with race-based jury strikes. That can't be right. And the second path set out in Question 2 is for this Court to simply say that the Eddings violation in this case requires a remand to the trial court for sentencing and that the appellate court was wrong to perform that delicate task itself. This breaks no new ground. Indeed, this Court has on 5 separate occasions since the 1982 Eddings decision ordered resentencing for Eddings violations. Both paths get McKinney to the same destination, but they are separate. Question 2 is limited to the small universe of Eddings violations and how to fix them, and Question 1, by contrast, is about when sentencing proceedings lose their finality and are reopened. Fine waiving the rest of my time.
Well, what about Clemens? Because Clemens is a precedent of this Court that says that the appellate court can do reweighing. Is that still good law?
So we're on Question 2, and
Yes.
and with respect to Question 2, Clemens is not an Eddings case at all. Clemens is a case about whether or not an aggravating circumstance can be subtracted from in a resentencing proceeding. That's a much easier case than
right.
what
You say in your brief, erroneously including an invalid aggravating circumstance is fundamentally different from erroneously excluding a relevant mitigating circumstance. Why? I don't understand that.
Because what the Arizona Supreme Court task had to deal with here was a full-blown reweighing of everything, mitigating and aggravating circumstances, whereas subtracting one element is very different. And indeed, we know this from Clemens itself, Justice Kavanaugh, because the very end of Clemens actually brackets this case. It says, in a circumstance in which the appellate court is asked for the first time to weigh and determine evidence, that's different. And what case do they cite there? They cite this Court's decision in Caldwell. And in Caldwell, there's language after language saying appellate courts are ill-suited to making these determinations about a defendant and whether mercy should be given. They want to see the defendant in
That's
person.
a lot of the argument that Justice Blackmun raised in dissent in Clemens, of course, that the appellate court wasn't well-suited to do this, that this was really a mistake.
Correct. And our point to you is twofold. Number one, you can just take Clemens as existing law. I do think my second point is it's undercut by Ring and Hurst, but just it may be existing law, but it's only existing law with respect to the subtraction of one aggravating circumstance. And Clemens itself, as I say, brackets this. And then the second thing is this Court, I think, has really changed the rules since Clemens because of Ring and Hurst. And we're not saying that Ring and Hurst overrule Clemens. That's not our position. But just that I don't think it should be extended any further than its facts.
Mr. Katyal, the Court below only reached your first issue, whether this was a new proceeding or not. It didn't reach the second. If it had, what does it have to do? Shouldn't we be remanding for that second question? You have presumed that it would have to do Ring, but my colleague, Justice Kavanaugh, has raised the question of why not. Shouldn't we be letting that be aired below? Shouldn't we just reach the first question and leave the second open and let it be completely aired? I mean, there is at least one Arizona case, Stiles, where the Court, following Clemens, basically said it's only the appellate process that was at issue in the decision below, we can redo the appellate process without applying Ring and Hurst. I don't know if it would choose to do that again with new argument, but shouldn't we give it an opportunity to do that?
Justice Sotomayor, I don't think you have to here. I mean, either way, whether you viewed question 2 or question 1, the result would be a jury trial because Arizona law.
Well, that's your argument. I'm just saying, shouldn't we let the appellate court make that decision?
Well, I think the appellate court here has pronounced on question 1 and said
no, if we disavow it over that pronouncement. I take your argument, as I did in your brief, that finality is not up to the state court, or reopening finality is not up to the state court, that it's up to federal law. We have to define it for everybody. And if we told it to go through a new procedure, I don't know how that can't be a reopening. We told it, the only thing they say we said, and I take your argument, is broader than that, but assuming I accept their position that what they were told to do is to reopen the appellate process, then they were wrong.
So,
that's your argument, right?
Absolutely. Justice Sotomayor.
It was a new proceeding. So now shouldn't we remand it for them to decide what new law they apply, if any?
If you want to rule for us on question 1, we're obviously not going to be opposed to that. I don't think you have to rule on question 1 and not reach question 2 because the Arizona Supreme Court here did make a decision on question 2. Indeed, there was a whole dispute between us about what should the Arizona Supreme Court do, and briefs were filed. There's Joint Appendix pages 385 to 89. You have the state's brief on this saying, do this in the Arizona Supreme Court. And what we said is, no, Eddings requires under Caldwell, Clemens, all of those cases, a resentencing.
But they decided the question on a narrow ground that this was not a new procedure. If we disavow them that this was not a reopening, if we disavow their belief of that, then shouldn't we get an answer to the question they left open?
I'm not sure that they left it open, Your Honor. What they did was arrogate to themselves the power to conduct this resentencing
Well, at
proceeding.
what stage of the direct appeal was there an error, according to the Ninth Circuit?
There was an error. If we're talking about there was an error both at the trial court and at the Arizona Supreme Court.
But the Arizona Supreme Court conducted de novo review.
Correct.
Was it not? So wasn't the error identified by the Ninth Circuit an error committed by the Arizona Supreme Court?
And more. So there's 4 answers here, Justice Alito. First, I know my friend has made this argument in the red brief at page 38 that this is the Arizona Supreme Court's error only. That's not the argument in the brief in opposition, and I'm not sure 15.2 allows them to make the argument when it wasn't in the brief in opposition. And that's particularly true here because they told you in this 2016 when they filed a cert petition from the Ninth Circuit at page 30, they said that the error was actually in the
All
trial
right.
court.
Well, I mean, put aside these preservation issues, which we can sort out for ourselves. If the Arizona Supreme Court, in the decision on direct appeal, had made it clear, if it did not already, but assuming that the Ninth Circuit majority was right, if they had made it clear that they were taking into account the mitigation evidence, irrespective of whether there was a causal connection with the commission of the offense, would there have been an error?
If there were no trial court error on Eddings, we wouldn't be here. Our position is not.
All right. Let's assume there was a trial court error, but the Ninth Circuit said we're conducting de novo review, and we're going to do it the right way, and we take the mitigation evidence into account in the way that Eddings requires us to do.
And I don't think this Court's precedents allow the appellate court to fix the trial court error. Decisions like Caldwell say that that's a decision for the sentencer at the trial court where they can see the defendant, confront the witnesses, and in cases like Arizona, there's a double circuit breaker function served by the scheme because they have to win both no death sentence, they have to win a death sentence both at the trial court and at the Arizona Supreme Court. And what they're seeking to do here is fuse that into one thing. Just as long as it can be fixed on appeal, that's enough. And what decisions like Caldwell say is, for juries, for Eddings errors, you need to have a trial court consideration of that.
maybe I must have the facts wrong, but maybe. But look, the trial court says a long time ago, there are two aggravating factors, A and B. And then it looks at the mitigation. And the mitigation is he had a terrible childhood, and the trial court says, that only counts if it's causally connected. That's a mistake. Mm-hmm. Then it goes to Arizona Supreme Court. And they say the same thing. They say 1 and 2 aggravating. And now we independently say this causal thing. Yeah. You're wrong about the causal, says the Ninth Circuit. Back to the Supreme Court. Supreme Court says we will redo our reweighing. We will now not use causal. Why does it have to go back to if their law really is, if it really is, the Supreme Court can do this weighing, why does it have to go back to the trial court?
Because in Eddings cases, and in particular Caldwell, this court has said the trial court has to confront all this in the first place. At page 331, for example, you said, whatever intangibles a jury might consider in its sentencing determination, few can be gleaned from an appellate record. The mercy plea is made directly to the sentencer. There is no appellate
in
mercy.
Arizona, the sentencer is the appellate court. You could say there's something wrong with that. They'll say the sentencer is the appellate court.
And what this Court's decisions from Eddings on have said, no, you've got to remand to the trial court for a determination and not to the appellate court. And by the way,
I got that.
And Justice Breyer, in Arizona, State v. Bible says appellate courts can't take evidence and can't assess that kind of stuff. They're not institutionally equipped to do that.
But we don't have to send it back because of Ring. Is that true? I mean, Ring, if it's now current law that applies, can they do this? Can they say, yes, it applies, correct, but not to the aggravating part? Because the aggravating part was done correctly under old law. And that's not sort of an issue. Only the mitigating part's at issue.
So our position on question 1 is that they've conducted a brand-new sentencing proceeding, and therefore current law applies. That means Ring applies, and Ring
would make
and they haven't really gotten into, except for just saying, there's no Ring violation, what the possible violations are. Our brief at pages 30 to 34 does outline them and says, the weighing and the mitigating circumstance and the taking of an aggravating circumstance without a jury determination, any of those are separate Ring problems.
So on question 1, why would Ring apply? I guess the issue is the defendant getting a kind of windfall if Ring applies? The error here has nothing to do with Ring, and Ring only comes into the picture because the court is trying to correct a different error. Why is it that, a non-retroactive rule should all of a sudden pop up and the defendant get the benefit of that rule?
We don't think that there's a windfall here, and I'll explain why, but if you do, that would just push you into the direction of question 2, in which you don't have that feature. But with respect to a windfall, I don't think that exists here. All our argument is that the State is conducting a brand-new proceeding, and that new proceeding has to comply with current law. So we're not trying to use the Eddings flaw, to reopen old grievances and say, there was this problem in the trial or that problem in the trial. It's just that the fact after the Ninth Circuit granted the conditional writ, the State affirmatively, you needed brand-new State action in order to sentence McKinney to death. And our problem is with that brand-new action, not with something that happened back before in 1993, but with what happened later.
You're requiring a new jury sentencing 28 years after the murders, and after the victims' families have been through this for 3 decades. And that's not required by Clemens. I take your point on that, but the whole point of Clemens, and I understand your argument, was the appellate court can do this. And there was a passionate dissent, you've read it, by Justice Blackmun saying this was really quite wrong to allow the appellate court to do this. But the Arizona Supreme Court, presumably aware of that law, did it itself. And why go back to a jury resentencing 28 years later?
Justice Kavanaugh, I think in many of the Eddings cases you've done exactly that. In cases in which there's a doubt as to whether or not the jury or the trial court considered mitigating evidence, you've sent it back to the trial court for resentencing and indeed for a jury determination. You did it in Eddings itself, you did it in Penry, you did it in Mills. Case after case, that is the result of this Court's precedents. And I think it's right because we're not talking about some technical violation here or something. We're talking about the heart of what capital punishment sentencing is all about, the weighing of mitigating and aggravating circumstances.
That was true in Clemens, correct?
Correct. And again, but in Clemens, it was just the subtraction of that one factor, and indeed they bracketed.
But the big point of the dissent in Clemens was, look, this is something the fact finder should do, the fact finder, the trial court should do, which is hear all the evidence and do that weighing. And that seems quite similar, and I'd still take your point, but quite similar.
Right. I think it's still different because it's just a much more limited question on appeal in that circumstance. Here, you are asking, and this Arizona has a de novo, brand new, full reweighing procedure. You're asking them in that circumstance to decide something that a jury has never seen or a trial court's never seen. And, cases like Caldwell say for mitigating evidence, mercy is really important. And, to have the appellate court decide this really fundamental question without even having the defendant before it, without having the witnesses, that's something I think that's new. At least in Clemens, I should have said this, Justice Kavanaugh, at least in Clemens there was a trial court determination at some point of the mitigating and aggravating circumstances.
Why are you not asking for a windfall, indeed maybe a double windfall? You are effectively getting retroactive application of Ring, which is not retroactively applicable to anybody else. And not only that, what you really want, I gather, is a jury is not the correction of a Ring error. It is another shot at convincing a jury to hold that somebody who is going to be found death eligible, in all likelihood, should nevertheless not get the death penalty.
So it's a limited correction because the Ninth Circuit's invalidated the sentence, so it requires a new sentencing if they want the death penalty. It doesn't allow us to, for windfall, for example, reopen guilt or innocence or anything like that. That was not touched by it. So it's limited to that. And in that sense, Justice Alito, it's kind of like when the court decides an ineffective assistance of counsel claim in a capital case. Yes, in one sense, I guess it's a windfall because lots of issues are reopened there, not just one. But that is, I think, the result of a precedent that says, hey, you need a full resentencing.
No, there the ineffective assistance of counsel can have all kinds of effects. I mean, you have an entirely formalistic argument, and maybe it's right, but why don't you just admit it's entirely formalistic? You want effectively a retroactive application of Ring, and your real beef is not with the lack of a jury finding on eligibility. It's with the actual sentence that the jury decided to impose.
I couldn't disagree more profoundly with that. That is that what we're seeking here is not formalistic. What we're saying is that there is new state action as a result of the Ninth Circuit's decision. We're not saying Ring allows you to reopen, for example, the jury trial rights on guilt and innocence or anything like that. It's simply that they needed to come in and have affirmative state action if they wanted to have a death sentence, if they wanted to have a final judgment. They needed to come in and do a new proceeding.
Mr.
In 2016, and our problem is with the new 2016 proceeding.
At the risk of a formalistic question, normally states are the definers of their own procedures, their own state law. And I would have thought that normally, at least, a state gets to define when its proceedings are final, for state law purposes at least. What federal law and what standard of review would apply to determine whether that state law violates the federal Constitution?
So, Justice Gorsuch, two big answers here. One is we're not in that circumstance because Arizona borrows from federal law.
Let's just say we are. okay? Stick with my hypothetical, if you don't mind.
Okay. And with respect to your hypothetical, I think this Court has said from Richfield Oil on in 1946 that it is a federal question, not a state question. In cases like Gonzalez, you've said you don't want to have state-by-state definitions.
I accept that there could be a federal rule of decision for vindicating some federal constitutional principle. But what would be that federal constitutional principle? And whatever it is, you're going to say due process, equal protection, I'm looking forward to that, but whatever it is, I would have thought that it would have been a pretty deferential standard of review by this Court to maybe assess whether there are efforts to evade a federal interest.
I think this Court has said that that it is purely a federal question and hasn't deferred in all of these different cases.
Is it federal common law? I mean, what's your source of law?
I think it's Article 3 in the Supremacy Clause because
the Supremacy Clause vindicates
exactly
other federal laws, and so I'm still waiting for what that other federal law is.
It is that if you allow state-by-state definitions of finality, allow them to define around the problem, then you have, for example, Batson problems and a return to the Linkletter world, which Justice Harlan was so worried about, the idea that you could just pick and choose when a state could apply current law and when they could say, oh,
right,
no.
I give up on that one. How about the standard review?
So we don't have a beef really with the standard review. I don't think this Court has ever given any deference, but even if you were to give deference in this case, you'd be giving deference to actually a state using a federal definition, because they never cite the Arizona Supreme Court when they say
well, they say it's an independent procedure and that's different in Arizona, and it's a kind of an unusual procedure.
Yeah, no. They cite Justice Gorsuch, this Court's decision in Griffith, and federal law entirely through and through. There is no cite to anything in Arizona, Michigan versus
Just
Long.
Suppose I disagree with you on that for a moment. You still want to win, right? So what standard of review would you have this Court apply in these circumstances?
Well,
something stronger than rational basis review?
We would say that it doesn't, that there is no reason for it to be deferential because you are talking about federal constitutional commands. So you would just apply, a de novo standard. But even if you wanted deferential, rational basis, right, whatever it is, here this is met. Here they are having a brand new sentencing proceeding, the heart of what capital sentencing is all about.
Mr. Katyal, a lot of your argument, you've talked about ineffective assistance examples, Batson examples, but not every violation of federal law cuts across the entire proceeding as ineffective assistance or Batson.
Correct.
Do you have a line to draw between those that do and those that don't?
Our line, Mr. Chief Justice, is if the new proceeding violates current law in that circumstance, and in that circumstance only, is there a argument limited to that? So
there's no difference between sort of a surgical mistake that could be corrected and an entirely comprehensive mistake that infects the whole proceeding.
No, that's a separate kind of safeguard against their open the floodgates argument, because as Justice Sotomayor, when she was on the Second Circuit, said in Burrell, and many other courts like the Florida Supreme Court have said, if it's just a technical correction, if it's ministerial, then you're not reopening the final judgment. We absolutely agree with that. This is the polar opposite.
Well, somewhere between ministerial and entirely comprehensive, there are things that are discrete and focused, yes, that suggest that the new proceeding, to give you the benefit of that, is not one that can't be is one that can be cured relatively easily.
Right. And our point, the line is, and this is what Burrell and other cases say, if the new proceeding requires an exercise of discretion, then current law applies to that new proceeding. And yes, I agree with, that there can be difficult cases in the middle, but this is the outlier. This is a brand new, full-blown, 100% redo of what happened in 1996.
So the part of Clemens that you say may still be good law, suppose that the appellate reweighing occurred not on direct review but on state habeas in the state Supreme Court. Is that a possibility in your view?
So we don't think anything turns on the label state habeas or direct review or anything. It's fundamentally a substantive question, what's going on. And
could they do that, though, the Clemens reweighing in the state habeas proceeding?
If they did the same thing here but called it collateral or habeas, it would make no difference whatsoever.
So I think your answer is no, they couldn't do that.
It's ultimately substantive.
Why not? Why can't a state do it in that fashion?
Because then you'd give the state the power to relabel something collateral and evade Batson and things like that, and that's a return to Linklater and allowing different and disuniformity between cases. And that's fundamentally what I think this Court's finality jurisprudence and Jimenez is all about trying to avoid.
Thank you, counsel. General Skinner.
Mr. Chief Justice, and may it please the Court, I believe there's actually only one path forward here for petitioner. Effectively, QP1 resolves the resolution of this case no matter which way it goes. If there's retroactive application of Ring and Hurst and all current law applies, Arizona does not contend that we have Ring-compliant aggravators here, and this would be a case that we would take back to the trial court. To the extent that there is no retroactive application, Clemens is the governing law, and what Arizona did fits entirely within Clemens. All of the cases involving trial court remands under Eddings from this court the petitioner has cited predate Clemens. Caldwell predates Clemens. All of them do. And there is no difference, to pick up on something that Justice Kavanaugh mentioned, we don't believe that where the record is built, which is critical here, where the record is built, credibility determinations have been made, the expert for the defendant has been credited in the trial court over the state's expert, that there would be any problem with the appeals court conducting its own independent review. Caldwell in these cases discussed some sort of new evidence that was never heard, and counsel keeps mentioning things as if never seen, the evidence was never seen, the evidence has never been heard. But the PTSD expert testimony was credited. The existence of PTSD has been credited. These are determinations that have been made, and the only allegation coming out of the Ninth Circuit is that there was an error of law in how those facts and evidence were treated. Turning to question presented one, the language of the writ that was issued is critical here. It is a conditional writ that does not require vacating the sentence. The parade of horribles that comes forward out of petitioner and amici really turns on the idea that somehow a state could all of them are answered by the idea that we admit if a sentence is vacated, that undoes the final judgment in a criminal case. That is the touchstone of what a criminal case is. Petitioner keeps mentioning that he doesn't want to challenge anything earlier in the case, but yet he cites cases in which this Court has held that the sentence is the judgment and that if you undo the sentence, then you undo the finality.
If the Court had done this proceeding, it says it's not a reopening of the judgment, but if it had done this proceeding and changed its mind and said, you know, it wasn't causally connected and we were following our old rule, but it was fairly powerful evidence, and we think he shouldn't be subjected to death. Could they, unless they reopen the judgment, have modified the judgment?
They can modify the judgment in the same manner that a 2255 court can modify a judgment, which, you know, even in —
How? You have to open it to modify it, don't you? You have to undo it to change it. I've never heard of changing a judgment by not undoing it first.
There are petitioner cites, for example, the Burrell case out of the Second Circuit, and that's an example where this Court has recognized that even in the context of a direct appeal, where you're making a change and it's the only change that can be made, and here there's only 2 sentences available, we believe that if the Arizona Supreme Court had decided that the mitigation was sufficiently substantial —
But it used a well-known exception in the law, a ministerial exception, and defined ministerial as being — since I wrote it, I know what I said — it defined ministerial as being with no discretion. You know, you enter the wrong date, or you accidentally enter the wrong amount. If you had no choice but to enter X as opposed to Y, that's ministerial. But I've never heard of changing a judgment that's substantive unless you've reopened the proceeding.
The 2255 context has cases that discuss the 2255 court is tasked with correcting a sentence and may well correct a sentence in connection with the collateral proceeding.
But that supersedes the old one, right?
We agree that it would supersede. I don't know that —
So let's go to the ultimate question. If something can be modified, if a judgment can be modified, it seems like more than semantics to say I didn't reopen it for reconsideration. Can't reconsider what I want to change.
That standard would change 2255 proceedings into direct proceedings for purposes of retroactivity. And a 2255 proceeding, a sentence can be modified. And yet, this Court has been very clear that a 2255 proceeding doesn't include application of current law. It is retroactive rules aren't applicable. So this is an aspect that requires balancing the technical and the reality, but it is pretty clear that in charting a modern retroactivity.
Could you go to my other question? It'll be my last with you. Assuming that we say that this was a reopening of the appellate procedure, do you lose automatically?
To the extent that this is a reopening of the direct appeal,
direct
appeal, then we would be back on direct appeal and the Court would be overturning the State's conclusion about the nature of the proceedings, but that would place us into the realm of what this Court discussed potentially in Jimenez. But that would require looking past what the State has said about its own proceedings and even, as this Court has said in cases like Wall, the entire definition of what is collateral is a judicial reexamination of something.
But General Skinner, the Ninth Circuit found that the Arizona Supreme Court erred on direct review of the trial court judgment. If they made an error on direct review, how can that error be cured without reopening the direct review? And they said you did the direct review wrong, do the direct review over. I think that one of the Justice Hurwitz, who said it was a do-over. It was a do-over of direct review. There was nothing collateral about it. There was an error on direct review, so we sent it back for a new direct review.
Two examples that come to mind, Justice Ginsburg, of where a collateral proceeding can resolve a constitutional violation. Here, for example, to the extent that the Ninth Circuit in Bank engaged in harmless error analysis as to the Eddings error, we recognize that they did not hold it to be harmless. But to the extent that they did that, if they had reached the opposite conclusion, that is a resolution, it's an identification of a constitutional violation, and a resolution of that violation in an entirely collateral proceeding. Similarly, when there's appellate ineffective assistance of counsel brought up in a collateral proceeding, the second
I don't understand how it's collateral when the Ninth Circuit said you erred not in a collateral proceeding, you erred in direct review. So do direct review over.
So they didn't say do direct review over, but my point was that the Ninth Circuit in engaging in harmless error analysis is itself attempting to resolve a constitutional violation in a collateral proceeding. The Ninth Circuit is sitting in habeas. It's not a direct proceeding. They've identified an error in the direct proceedings, but they are demonstrating that in certain circumstances this Court and other courts will.
Well, just on the same line, General, I mean, yes, it's a federal habeas proceeding, but federal habeas courts only have authority over state direct proceedings. They don't have authority over state collateral proceedings. They were reviewing a state direct appeal, and they said the sentencing was not done right. You have to do the sentencing again. So which sentencing are we talking about? We're talking about the sentencing in the state direct appeal. So whatever you call it, you know, people have talked about formalism, whatever you call it, you're redoing, aren't you, the state direct appeal sentencing?
So there's a couple of responses to that. The first one I would point out is to the extent that the Ninth Circuit believed that a new direct proceeding had to be engaged in, and the State instead engaged in a more narrow, which I will get to, and collateral proceeding, the answer wouldn't be that that proceeding has now become direct for purposes of retroactivity. The answer would be, just as occurred in the